The Supreme Court. The petition that was filed by the first petitioner, to recap it, was a very simple, by the second petitioner, I think we are the second petitioner as amended, was very limited to a legal issue. It was, what was the position vis-a-vis the election and the role of the commissioners? Now, yesterday, and I think Justice Lenola said something about tweeting and stigmatizing, but in a nice way. When this petitioner came, and I had said it in my opening address, and yesterday Mr. Ngatia said, senior counsel said something very, very, I mean, it's our country. He said, this is one country that even the humble can go to the top. But there was a caveat that seems to have been missed out. If you are a normal, humble person who comes to challenge a presidential election as required by the law, you still get targeted as being a surrogate, because that was repeated 3 times. So there seems to be caveats in these things that we don't seem to know about. Yesterday, my lady, Justice Njoki, asked a very direct question. What is the role of these 6 commissioners and the chairman? Because we seem to be getting in a very empirical chairman. This morning, we got absolutely no idea, except the court was taken to Section 11A and B of the IEBC Act. We were told nothing more. From what I can now see is that these 6 commissioners are supposed to be flower girls and page boys at a wedding, with the chairman being the bride or the bridegroom, as the case may be. That surely was not the intention of the Constitution. It appears that that's because I was actually waiting for that answer just as much as your lordship and lordships and ladyship was there was nothing given. Please go to 11A. That's all you were told. We have an umpire, and I'll use it in the cricket term because in football it's called referee. But here in the cricketing terms, it's called an umpire. It is supposed to be an independent umpire. But I heard some I was a bit surprised yesterday when I heard words like shock and awe tactics. And surprisingly, the shock and awe tactics actually came out in one of the protagonists, the ones, the protagonists of We've Won, and that was in one of the affidavits. And these are the direct words that an umpire is using. So how is this umpire as independent as they are claiming to be? That is my client's case, that we need an independent body. The second one, we were told by the umpire, get over it, quote, unquote. We were told by one of the protagonists, move on. If there has been a breach of a constitutional, and as it has been our submission, Article 138, 3C, if there is a breach, do we just move on? That's what we are being told. Forget the transgressions that anybody is doing. Justice Lenola, in the opening day after the petitioners had made some submissions, asked a question which I didn't see anybody answering. He asked a question regarding Regulation 87.3, where he had stated that if it should be struck down, but it's already been done. So, that was the regulation which was in place. If your lordships and your ladyships will look at my submissions, my original submissions we had filed, and we specifically addressed that issue. What is a nullity is a nullity, and I believe it was in the McFoy case, it's an English authority, that we have quoted in our original submissions. So I hope, Justice Lenola, it answers your question.
Thank you.
Because I think nobody here actually took those questions seriously, they didn't answer them. And I don't mean to be disrespectful or being facetious at all. As far as from what I can see, is that this, by the law, by Article 138 3C, it says commission. We were told commission, but it doesn't say commissioners. That was a distinction being made yesterday. It says commissioners, doesn't say commissioners, but commission. With due respect, all those commissioners are appointed, well, not at the same time, but go through the same rigorous process. Does it mean all animals are equal, but some are more equal than others, which means the chairman is more equal than anybody else? These, like I've said, and I repeat again, are just flower girls and page boys. That surely cannot be the intention, could not have been the intention of people who drafted this constitution. We go back to where we started from, and I've said that in my original submissions. Where did we come from? We need to know where we came from. One-man show? Surely that cannot be the issue. The other issue that the Chief Justice asked everybody, and that's where my client, that there were all these problems, these commissioners had walked out, the transparency, accuracy. Nobody has given us that answer as we sat through this today. You specifically asked, Madam Chief Justice, why was it not declared that there were these problems, 27 constituencies? Nothing. We couldn't do it because there was a problem. I don't want to go into MATIANG'I case, but you were quoted paragraph 287 of the Supreme Court, which I called RILA, which was RILA 1 or 2. But please, before just looking at 287, please look at paragraph 292 of this court's decision. I don't want to repeat it, but this court specifically said, it is in my original submissions, we fault the appellant, who was the IEBC, and the chairman, who was the current chairman, for there being no verification by the commission. We've been told we've misread the section because it's polling stations. With due respect, if it was going to be only polling stations, why send it to the National Tallying Center? It is for the public to know there were mistakes here, there were no mistakes, whatever else there was. A question was asked by the court yesterday. Why did the running tallying stop? Nobody's given us an answer. All the difficult questions that we were to get answers for, to which my client, as a voter and as Wanjiku, I keep on saying, we have not received any answers whatsoever. No affidavits. In fact, the sad part is, despite this whole matter being consolidated, we were considered the surrogates. Nobody sent us any papers to sign. I have two requests from this court, as I have said, and this was what I was thinking of last night before I went to bed. Where it is established that a state officer is subverting the Constitution and the rule of law, the court's hands are not shackled by procedural niceties. This is the beauty of this Wanjiku Constitution that we have. It's transformative, and some people say it's a very overused word. But in these circumstances, it's ideal and can bite when occasion demands. The toothless bulldog is long dead and buried. Please, Madam Chief Justice and honorable judges of this court, bite and bite for the glory of this court. And in closing, whilst we said, we were told our petition is much ado about nothing, and like I said, we've really been battered, but we shall soldier on. I will use Martin Luther King's words because I suppose, unlike Professor Guido Muigai and Mr. James Orengo, I went to a school where they didn't teach us Shakespeare, they taught us things fall apart. They went to the posh schools. And all Martin Luther King said in 1968, at the speech given at the National Cathedral, we shall overcome because the arc of the moral universe is long, but it bends to justice. That's all we request. Can we have justice for all of us, for the voters, because the two parties just think about themselves. They forget us, who are the voters. Thank you. And I donate my 4 minutes back to the court.
Thank you. We will have the third petitioner, Youth Advocacy Africa.